webinar today in English. So for all Russian colleagues that are listening to us, please know that we are speaking English today. And we will be talking about the new regulation related to online advertising, the so-called labeling of online advertising in Russia. We see that more and more colleagues are joining right now. We are very glad to welcome you here. And before we start, I think we need to introduce ourselves. My name is Irina Shurmina. I'm counsel and head of digital law practice at the law firm Seamless Legal. And here is my colleague Alisa.
Good afternoon, everybody. My name is Alisa Mikheeva, and I work alongside Irina at IP and digital law practices. I'm an associate. Happy to be here.
So you see now our rebranded presentation here from Seamless Legal. This is brand new thing, and we are glad to share with you this beautiful design on this webinar, alongside with all useful, we hope, information that we will share today. So we have a quite broad agenda today. We'll talk about many things. Please feel free to put your questions in the questions part of this functional. We hope to answer them all after we finish with the presentation. Hopefully, we will manage to finish the presentation within 1 hour or so, maybe a little bit more, because we have a lot of information, and then we will move on to the questions. So our today's agenda is we will first give you an overview of the new legislation on labeling. What is it all about? What is happening now? Then we will talk about applicability of the new law to foreign advertising, because we are talking now in English. We hope that our foreign colleagues will also be watching this. So we will talk about how the law actually applies, or whether it actually applies to foreign advertisers and advertising. Then we'll talk about the scope of the new law, what exactly should be labeled, how to understand where we are dealing with advertising, where it is something else. Then we will talk about how to label online advertising, like from the technical point of view a little bit, how exactly all those labels are put on the advertising materials. We will talk about contracts, because of course, due to all these changes, you need to change your contracts with your partners, with the advertising systems or other advertising channels. So we'll give our view of what exactly should be prescribed in the contracts. And of course, we'll talk about the liability and its allocation. And of course, we will give you some practical recommendations during the whole presentation that we will be doing today. Just, if we want to show briefly what the labeling of online advertising is, basically there is one simple slide that you will see also afterwards, but we decided to put it here as well, just to let you know very briefly what we are talking about. Labeling of online ads is basically putting advertising mark and information on the advertiser or its website on the advertising material, and plus obtaining and providing this ID, ad identifier, or sometimes it's called token. So basically, in the nutshell, this is what we are talking about today when we talk about labeling of online ads. This is what we mean. There are two parts: this advertising mark and information about the advertiser, and this identifier, ID, token, whatever. We will use different terms. And talking about terms, actually, we decided that for our international colleagues, it may be quite confusing and quite difficult. So we prepared this key definitions slide, so that you understand what we are talking about. So labeling of ads, I think we already disclosed this. There is also a funny term, which is originally English, then became Russian, and now we are switching back to English, and now it looks a little bit ridiculous, but still, it's called creative as a noun. So it's a draft online advertising in any form. So basically, it's something that you haven't published yet, but you need to register to receive this identifier. So if we are talking about creative, please know that this is kind of a draft advertising. ID token is a unique code consisting of letters and numbers that is assigned to each creative. Advertising data operator is a new subject of regulation here in Russia. It's an entity, there are actually 7 of them, authorized by Roskomnadzor and the government to process data on online advertising and submit it to the unified registry that we'll be talking about right now. So registry is a unified register of online advertising that is created right now. Roskomnadzor is the main regulator in terms of identifying this online advertising and leading this registry. And Federal Anti-Monopoly Service, this is the regulator dealing with advertising. So this was one of the most boring slides today in this presentation, but we felt that it is necessary to give you these key terms and definitions that we will be referring to today. So let's talk about the new legislation on labeling, what it's all about. And here comes the second most boring slide of our presentation today. We will not go through all these wonderful bullet points, but this is basically the whole list of legislation applying to the labeling of online advertising right now. Funny enough, before that legislation, we didn't have any legislation about online advertising. Basically, all legislation that was applicable to advertising was also applicable to internet or online advertising. Now we have like the list of 10 or more acts that apply to this matter. And it's not only the federal law on advertising, but it's also some governmental decrees, the regulators decrees, and they are changing constantly because the market is actually facing difficulties with the whole system. So even if you read the whole thing like 3 times because you cannot really understand from the first time it was written there, if you even read them carefully, you still need to be aware that there are changes and they're happening all the time. The process is ongoing. So here we also included 2 draft decrees. These are links, so if you're a Russian speaker or you have a colleague who reads Russian, then you can click on these links and have a look at those decrees. So finally, summary, just in general, what's going on? As of 1st of September 2022, all online advertisements are to be marked with the mark advertising and accompanied with information on the advertiser. For example, it can be the company name or its website. Prior to dissemination, publication of advertising, creatives, you remember, it's a draft advertising, they are registered with one of the advertising data operators. And each creative, each material is being assigned with a special unique ID. After publication of the advertising, parties like the advertiser distributor, and other parties involved in distribution of these advertising materials should submit reporting documentation to the registry and through the advertising data operator. The entire chain of contracts related to this placement and distribution of advertising should be registered, including all relevant prices. This data will be available in the registry, and other state authorities will be able to also look at this, access it, including the Federal Tax Service. Just a quick note that Federal Tax Service has not commented anyhow on this new system of online advertising labeling, but we expect that they may have huge interest in looking into this registry and seeing what exact sums of money were transferred from one party to another and what kind of taxes were paid based on these sums. So generally, this approach of marking advertising as advertising is not a new thing if you think worldwide, because in many jurisdictions, either on the level of law or the self-regulation, there were requirements to mark advertising as advertising clearly, so that the consumer can understand that this is advertising, not just some information. In Russia, we didn't have this thing, so we now have it, but it's not the only thing that we have right now. Another thing is actually those identifiers that would probably allow to bring some transparency to the advertising market and allow state authorities to look exactly how it works, who distributes advertising where, what money is there, etc. This system is not perfect. It's actually far from perfect. And even though as of 1st of September, we are living in this new reality, which has been already 3 months, this system is still not really working properly. So it's in the testing regime. I think this testing regime, this is what the regulators say, will last until probably March 2023. So business and state authorities, they're still figuring out how exactly this is going to work. But if we sum up the whole thing that I told you right now before, we prepared just a simple scheme how exactly this should work. So there are regulated entities like advertisers, advertising distributors, advertising system operators. They first need to register all the creative materials before dissemination of the advertisement with the advertising data operator. And after they place their report on the advertisement after dissemination. All this information goes to the regulator, to the registry. Then other state authorities can access this information. And then after the whole system will work, finally, it is expected that the regulator will have the selective advertisement check. So they will pick some advertising and check whether there was identifier, whether the reporting was done properly, whether all information is actually in the register. And also these advertising data operators, they will be able to monitor and analyze this advertising also somewhere in 2023. To be honest, right now, these operators, they have enough things on their table, so they do not worry about this monitoring, and they have not developed the system yet. But this may be the case somewhere in 2023. So we will have like 2 levels of control, kind of, from the regulator and from these entities that are advertising data operators. Probably you're wondering, who are these lucky guys who became these advertising data operators? And there are 7 of them. These are actually commercial entities. More than that, they are not only commercial entities, but they are commercial entities who are dealing with a lot of advertising. A lot of online advertising is distributed via these platforms. So this is Yandex. It's one of the, I think it's major advertising platform here in Russia. Then it's Ozon, it's a marketplace, but also they have a lot of online advertising instruments in this marketplace. MTS, it's a mobile operator, as well as Wimpel.com. They created their own operators of the advertising data. And VK is like Russian social network, also having a lot of monetization with advertising. So they also created their operator. Sber also is like an ecosystem. They also have a lot of advertising opportunities, and there is also one operator called Amber Data. So these are 7 entities. And this is basically, it's not a normal, a standard thing to have this kind of entities that are assigned by the government, but still, there is not one, there are 7. And this is kind of a competition between them because they provide the functional, they provide their systems, they fight for clients, and you can choose with which operator you can work, unless you, for example, distribute advertising with one of their systems, and then probably you will have an obligation to report through this particular operator of advertising data, because for them it's much simpler. You know, they already have your information. You don't need to do anything. For example, if you spread through Yandex your information, your advertising, they already have everything, so they will just report everything that is needed to the regulator. But it would be weird if you go to another operator with this information. So it's necessary to check your contractual obligations with the advertising systems where you work with your advertising. Maybe there is already a prescription where exactly you need to report this particular advertising that you place on these platforms. And we decided to include these 2 screenshots from the registry, how it looks like, just to give you some image of this. This is the register that is administered by the Roskomnadzor, the regulator, and basically any commercial entity can enter this system with help of their electronic signature, let's call it this way. And they can see what kind of agreements are reported to this registry and what kind of creatives or advertising materials are reported there as well. It's still under construction. The first reporting happened only in October, so we don't really see information in register yet. But it is expected that, for example, advertiser will be able to enter this register and see the whole chain of advertising contracts and probably some sums of money that were spent on this advertisement placement. So we'll see how it is going to work. So the regulator is still adjusting the system. They are in tight contact with the operators of advertising data and actually with the whole industry. And we'll see how it will work, I think, pretty soon. So this is the overview of the new regulation, of the new rules. Let's go to the next section and talk about the applicability of the new law to foreign advertising.
So here it needs to be said that a lot of our clients are asking, does this law apply to us? And the problem is there is no clear answer, because neither the law on advertising nor the law which introduced new changes regarding labeling contain any specific provisions regarding its applicability to foreign websites or foreign advertisers. The only answer that we get from Roskomnadzor and other authorities is that if an ad targets a Russian audience, then it should be labeled. It should be subject to this legislation. So the only thing we can do is look at the existing criteria which apply in other areas, and one of such set of criteria are targeting criteria. This terminology and this approach was elaborated first by Russian courts in consumer protection disputes, and later it was also applied by Roskomnadzor, Ministry of Communications, and other authorities in personal data protection matters. So they have established that when a website has the Russian language version, or the website is located in a Russian domain area, so it has the domain name .ru, .rf, etc., then primarily this indicates that the website is targeting the Russian audience. These are so-called main criteria of targeting. There are also additional criteria which can be useful when a website has a Russian version but does not really collect any money from Russian users, for example, any data, personal data of users, etc. So this is why additional criteria were also included into this approach. So one of the following criteria needs to be present as well. First, the website could allow payments in Russian rubles, or it allows to perform a contract which is concluded on the website via the website, but is performed on the territory of Russia. Thirdly, when an advertising, when the website contains an advertising which is in Russian or refers to a Russian audience. And lastly, just very generally, any other circumstances could be present which indicate the intention of the website owner to do business on the Russian market. This is a very general criterion, and it can really apply to any website. So this has existed since 2012. This has been constantly applied by various courts and state authorities, and this, we believe, will be the guidance criteria for Russian authorities to apply the new law on labeling as well. But there is also a second set of criteria that we would like to talk about. This is the new law. Actually, it was adopted in 2021, the so-called blending law. The idea of the law was to make large foreign IT companies such as Facebook, TikTok, and YouTube, etc., to open up a branch in Russia. So the Russian legislator wanted to make these websites comply with the Russian laws. And for that, of course, it would need to have a legal presence. So they have elaborated the following criteria for the websites and apps to be considered as fulfilling the criteria to set up a business in Russia. The first main criteria is the daily audience of the website. So if a website or app is daily used by 500,000 users, then primarily it should be included on the register, and the company should be registered in Russia. There are also additional criteria, and one of them needs to be met, and they resemble the targeting criteria that we just talked about. So either the website needs to have a Russian version, or the version in any other state language of the republics of Russia, or the website should be disseminating ads which are aimed and targeting Russian consumers, or the foreign entity which owns the website processes personal data of Russian users via this website. And lastly, a very standard thing, if the website receives funds from Russian individuals, I mean the entity owning the website, of course. So when we look at these two sets of criteria, they are actually very similar if you look at it. So there are really three main things that are looked at. Firstly, whether the website features any information in Russian. Secondly, if it features any ads which target Russian consumers, the products which Russian consumers can buy, an online game, for example, they can download. If an ad contains that kind of information, then it is targeting the Russian audience. And thirdly, also very general, financial approach. If a company receives funds from Russian users via this website, or if it just carries out business in Russia, then of course the Russian authorities will probably consider that the website and the ads located on it do target the Russian audience. So that is what we recommend to look at first if you have a website, or if you have some ads which are published on third parties' website. Check this website on whether it does have information in Russian, or if payments in rubles are accepted, and just consider for yourself that this law might be applicable to you.
Yes, thank you. So we're moving to the next important question, is the scope of the new law, what we should label. And to answer this question, we actually don't need to look into the new law, new piece of legislation. We need to look into the basics of the advertising law, of advertising regulation. We basically need to answer the question, is it advertising or not? So we look into the Article 3 of the law on advertising, where there is a definition of the advertising, which says that advertising is information in any form, any means, any medium that meets two criteria. First, information is destined to attract attention to the goods, services, promote goods, to form or maintain interest to these goods or services. And the second criterion is that information is addressed to the indefinite range of persons. So the most important thing to remember is that information is a much broader term than advertising. Advertising is just some part of information that meets this criteria. This, in terms of labeling, this means that not any information on the internet and not every information on the internet should be labeled and marked with advertising, because we see now that many lawyers and non-lawyers and marketing people who are dealing with labeling, they are so frightened that they started actually labeling some information that is not advertising. So it's really important to understand where is the threshold between just general information and advertising. So these two criteria are the main source of information for that. But let's go further, and we see that the law on advertising has its scope of application. And there are some exemptions that are directly provided in the law on advertising. So Article 2 says that the law on advertising does not apply to information and analytical materials that they do not, if they do not serve to promoting goods and services as a main purpose. So any statistical researches or analytical reports, or maybe some reviews, for example, of some products, if they are not aimed at promotion of one particular product or two particular products, they are not advertising per se. Then something from offline world, signboards and signs not bearing advertising, and information placed on goods and their packaging. And finally, references to goods, services which are seamlessly integrated into works of art, literature, or science and do not have characteristics of advertising. If we just say, maybe not very in law language, but just in just our common language, it's basically product placement. And this final exemption was normally applied to cinema, to cinematographic, some works, or probably to news, where there were disputes whether in news there was actually advertising or it was just information. So it was just a classic approach. But now with online advertising, it's also interesting that this exemption can be applied to, for example, bloggers, to YouTube videos, to some articles on the internet, etc. And we will talk about this a little bit further, but this was approved by the Federal Anti-Monopoly Service, who said that this exemption is also applicable to the online advertising, which is great news actually. What else can we use? There were several useful clarifications from the Federal Anti-Monopoly Service about the threshold between advertising and information. This one from 2019 is, I think, the most useful one, because now everyone is referring to it. So there, Federal Anti-Monopoly Service said that they do not regard as advertising search results we're talking about plain search results, organic ones. Directories and classified websites, like in Russia, it's Avito, Tsian, and others. And information on goods producer seller's own website, provided that such information is destined to inform on the range or assortment of goods or a company's activities. So this third bullet point is very useful right now, because basically it says that your own website from the company, where you tell about the products, where you tell about your activities, maybe your events, or some awards that your company won, per se is not advertising. But in the same letter, the Federal Anti-Monopoly Service says that it is advertising if it's a contextual advertising or search targeting, search advertising, basically, but there is no dispute about that. And banners bringing special emphasis to particular goods or services, for example, on your own website. So for example, if the company states about some general activities, there is a catalog of goods or services, and then there is a banner that brings attention to a particular good or particular service or particular event, bringing people's interest to this and basically selling this, not only informing about this product, then this can be advertising. It doesn't make the whole website advertising, but it makes this particular part advertising. This means that you need to label it and you need to report. Another very useful clarification from Federal Anti-Monopoly Service, it's very recent, it's just, I think, last week or something, clarification from the Federal Anti-Monopoly Service about, it was initiated by the Association of Bloggers and Agencies, and we also participated in this discussion and agenda. So basically, there was a question, where is the threshold between advertising and information for bloggers? What they actually need to label, what they don't need to label. So this was kind of a discussion, after which the Federal Anti-Monopoly Service issued these useful clarifications. So first thing that they said, it doesn't say a lot of new things, this particular part, but it's still, again, very useful. So information is advertising if some particular goods are paid special attention, there is excessive and positively emotional information that is given by, for example, a blogger. This is something new. This we didn't have before, and it's very interesting how exactly this will be assessed. I expect some psychologists probably on this, meetings with the Federal Anti-Monopoly Service, where people will see whether it was a positively emotional information or not. But yeah, we'll see how it will develop. And the third criteria here was that it is advertising if there are calls to buy the product, including at specific marketplaces, shops, if, for example, there is a link or address or promo code or whatever. So some guidance how to buy this product. And to be honest, I think these criteria are understandable from the general public point of view. So if you look into some social networks, we will not name any of those, some social networks, and you see some posts from the blogger, and you see that they are providing promo codes and links, go there, buy this with this discount, most likely it is advertising, and we know all this already as experienced users of social media. So this is the first thing that Federal Anti-Monopoly was asked and replied to. Then they said that bloggers' posts, videos, or reviews are not advertising, which is great, but there is also if. So if references to goods, producer, seller are seamlessly, organically integrated into the works, and here we remember about the exception from the scope of the advertising law, which says that this product placement or organic integrations, they are exempted from the advertising. So if blogger manages to include information about the product, like in the seamless way, in the way of product placement, and it does not constitute advertising per se, then it's not advertising, and it shouldn't be labeled or reported afterwards. Such reference do not have characteristics of an advertisement. This is a general one, and there is no emphasis on the product's characteristics or features, no statement on the blogger's positive attitude towards the product. So it's just this product just appears in their regular life, sort of, and their regular communication with their followers. And then it would be probably organic integration in terms of the Russian law, and also the Federal Anti-Monopoly Service already long ago, like 11 years ago, they developed the criteria of this organic integration. Here we provide the reference to this letter of Federal Anti-Monopoly Service. Again, if you know Russian or you have a Russian lawyer, then it could be useful to read this one to see how actually to work with this organic integration. It's funny that it's actually like a seamless integration, and we are from Seamless, so we are destined to actually, I think, talk about this. So the final thing that the Federal Anti-Monopoly Service said in this recent clarification was that if an advertisement is placed on the internet prior to the 1st September 2022, when the law came into force, and all the contractual obligation on this placement were fully fulfilled by this date, then the new requirements on labeling and reporting are not applicable to it. So if you place some, I don't know, advertising article, for example, on your website before 1st of September, and you got paid for this advertising article before the 1st of September, and you had all your closing documents before that date, then you are not required. And this, for example, this article still can be on your website, but somewhere in archive, for example, you are not obliged to comply with this labeling requirements, but it's probably important to have a date of publication on your website, so that in case of some monitoring or check or audit or case, whatever, you will have this proof that this information was placed long before 1st of September 2022, and all the contractual obligations were also fulfilled. So if we sum up everything that we said about this information and advertising criteria, about the clarifications from the regulator, so here are the criteria of information and advertising. So criteria of advertising, first one, it's attraction of consumers' attention to specific goods or services. In contrast with that, criteria of information is general information on the company's activities, range of goods, services, etc. Then criteria of advertising, distinguishing specific goods from the rest on the website or social network or any other place. So if you bring attention to a particular good or service. And in the contrast, the criteria of information is that information is arranged systematically, uniformly styled, without distinguishing specific products. And finally, from the recent clarification of the Federal Anti-Monopoly Service, criteria of advertising is that there is excessive and emotionally charged information about specific product, calls to buy the product, shop details, promo codes, whatever. So this particular information from bloggers most commonly. And to the opposite of that, the criteria of information is that information is seamlessly integrated and does not itself bear the character of an advertisement. So it's a common use of this product, for example, by this blogger. There are no links to the shops, etc. But in any case, and the Federal Anti-Monopoly Service says this all the time. And we as lawyers who answer a lot of questions about what is advertising, what is not, we also say this, that we judge on a case-by-case basis. We need to analyze the content of your material. We need to understand what kind of format and design it has, how it will be placed, for example, on your website or in your social network. And also it's important to bear in mind the mechanics and factual relationship between the parties. For example, if you have a contract that states that this material is advertising material and you are paid for advertising services, and then you come to the dispute, for example, with the Federal Anti-Monopoly Service, and you say that no, it's not advertising, then of course it will be hard to prove that it's not advertising because your contract says otherwise. So it's also important to understand what kind of factual relationship you have, even if we're not talking about contracts, what kind of intent you have, what kind of intent has your partner. So all these kind of things should be analyzed, and this is what we analyze when we deal with this question, whether this is advertising or not. But in general, any information, any question about advertising information can be put through this criteria, and it's quite helpful because you just isolate yourself from anything else and you go through this criteria, and actually they help you to find an answer, whether it's advertising or not, and whether it should be then labeled, reported or not. So let's move to the next question: how to actually label this online advertising that we are talking about so much. Alisa.
So yes, from the technical point of view and from the visionary point of view, we would like to show you some examples of labeling. But first thing we need to remember is that labeling consists of two elements, as we already mentioned. The first one is accompanying an ad with an advertising mark and accompanying it with information about the advertiser or its website. And this information is provided to the consumer, to the audience. So he or she, a consumer, can easily understand that this is an advertising, this is not something else, and this makes things honest for the consumer. And the second element is, of course, an identifier, and that is mostly important for state authorities so that they can monitor compliance with the new law and check whether all ads have been duly registered in the system. So we'd like to show you some examples of how these two elements are showcased on an ad. The most common examples are, of course, banners, the classic online ads, and this is what the new regulation was really ready for, so to speak. So the information about the advertiser and the advertising mark is located on the banner itself. You can see the two examples where information is displayed either as a reference to the website on the left, or full details about the advertiser, as on the example on the right, with the legal name, the address, the registration, state numbers, etc. The idea is that the consumer needs to be able to understand who is the advertiser, what is its identity. So in case a company name does not ring a bell, or there are a lot of company names bearing the same name, it is advised to place some additional information, such as state registration number, for example. Or it can just contain a link to the website, and that is considered sufficient. And the second element, the identifier, yes, that is not so obvious how to display it on the ad. So the classic approach and the most commonly used way of labeling in this sense is integrating the identifier into the clickable link, which leads to the website. So when you click on the ad, you would be redirected to the website. You would not feel or know anything. But if you actually look at this link, if you copy it, you can see that the identifier ERID equals, and the identifier is incorporated, in fact, into the link. So that's done for state authorities. We understand that there will be special programs which will scrap information from the websites, and it will be done automatically. Of course, it's not expected that a Roskomnadzor official will manually copy-paste these links and check identifiers one by one. So there are some other examples, less obvious, that we'd like to show you. This brings us to Telegram, which is one of Russian popular social networks these days. And a lot of advertising is actually done through this app. So these are some examples from the account of a famous Russian blogger who was, in fact, one of the first persons who started labeling his ads with duly incorporated information about, you can see the advertiser, its details, and the ID. So when it is a photo, like on the example on the left, then all of this information is just included in the text of the message accompanying the image. So you cannot place a clickable link on Telegram. There is no technical functionality for that, but you need to place all information in a text message. So two other examples on the right are videos. There are so-called circles in Telegram, which are just short videos, and a standard video is on the right. And you can see that in each example, the identifier is placed in the text message after the video or with the video, like in the example on the right. And there are news, Irina, you wanted to tell about Telegram. There are news that it might be associated, incorporated, integrated. Yeah,
the regulator issued recently some recommendations about Telegram, how to place those identifiers. That's what Alisa just mentioned. And there was the statement that in case Telegram, or when Telegram integrates with one of the operators of advertising data, then this whole information will be processed automatically. All the statistics about the numbers of views and everything will be processed automatically. And then we had an event with these operators of advertising data operators, and we'll tell you about it a little bit later. And we asked them specifically, I personally asked whether they know about any plans that Telegram would integrate with operators, and they said no, they never heard of that. And we don't know whether the regulator has any other information, but so far, we haven't heard that Telegram would be planning to integrate with operators. So it would be interesting how exactly those identifiers will be automatically scanned or found by the program that the regulator would use. But at this moment of time, advertisers or bloggers, they don't have any other option. They need to comply with the law, with new requirements, and they need to place these identifiers, which are not pretty, but they have to do this, and the only way they can do this right now is this way. We'll see how it's going to develop. Actually, we really believe it will develop because there is a constant discussion of these issues with the regulator. So let's see. Or maybe Telegram will integrate with some operator, which I don't really expect to be soon. Let's move to the next example, right?
Yes, so the last example that I'd like to show you is a YouTube video, which is also very popular advertising means for Russian audience. And you cannot incorporate a clickable link into a YouTube video. So here, like with the examples with Telegram, you can see that the advertising mark and information about the advertiser, although it's not very well viewable, but it is placed on the video itself. somewhere in the video. Preferably it should be well written, well visible for the users. And the identifier, since you cannot place it on the video when you create it because you don't know the identifier yet, so it is placed in the text below the video. It should be stressed that this approach has not been approved by Roskomnadzor or other authorities. It is not yet clear whether this type of this means of labeling and placing the ID is in fact appropriate, because there are recommendations from Roskomnadzor that the ID should be placed on the video or in the clickable link or after the video. But here you can see that, in fact, a user may not really see this identifier at all because it is disconnected from the video. It's posted somewhere below. You may never open up this field and read the details about the video. But still, for the purposes of monitoring compliance, of course, this identifier probably can be scraped by a program. So it should actually serve its service, the idea behind it. We all hope for the better, and there is a draft decree by Roskomnadzor about the identifiers, how it should be placed, where, and we really look forward to its adoption because everybody hopes it will make life easier. But for now, there are some formats which are not so clear in terms of how to place these identifiers at all. So what we just talked about are YouTube and TikTok videos, some Instagram stories, the same thing. You cannot place an identifier into the link. You cannot incorporate it. I think even more complicated are audio ads and podcasts, which are actually quite popular nowadays. Some Russian social networks, for example, have a music digital platform, and between the songs you can hear a lot of advertising. So how to label that at all? I mean, should it be pronounced on the during the ad that this is advertisement and the advertiser it is XYZ? And do you just pronounce the identifier? It is not clear. So there is no answer to that for now. And other also problematic, so-called problematic formats are dynamic banners and product feeds, which are not prepared in advance. They are assembled based on various targeting criteria in respect to a specific user. So the system collects cookies, it analyzes it, and it just assembles a banner for you personally based on what you have looked for on the internet, what you have recently bought. So it is not predictable how this banner may be assembled. So once again, not clear how all of this is going to work. What Roskomnadzor always says during meetings is that we will be working with the formats that we understand for now, and we will look for your compliance. But of course, we understand that there are these unconventional formats which are not really understood for now, and the market and Roskomnadzor probably will just work out the ways how to label all of these wonderful ads.
Yeah, exactly. But this is in progress. So I hope we'll find more elegant solutions so that in podcasts you don't need to name the whole identifier. Hopefully not. So we'll see how it goes. There are also some exemptions from the new rules. I wouldn't be so optimistic about them, but we still need to inform you about them. So there is an exception for some types of advertisers. So the company's advertiser is a goods manufacturer, the goods seller, or holder of IP rights to the advertised object. Then this company is exempted from the obligation of reporting and receiving an ID, but only in case if this company contractually obliged the advertising distributor to report, to obtain the ID, to report to the advertising data operator directly or with an agency, it doesn't matter. So this basically just exempts these types of advertisers from the liability for this kind of things. But still, all information should be in the registry, and all information about all advertisers should somehow become available there. So it's the company's obligation to have some contracts that would oblige someone else to provide this information if the company doesn't want to do it itself. And also there is exemption by types of advertising. So there is an exemption from labeling and reporting for social advertising and advertising on TV and radio programs if they were distributed on the internet without any changes. So if there is basically a stream, for example, online stream of the TV or radio program, and there were no additional advertisings that were placed on this streaming channel, for example, on YouTube or somewhere. So if this TV flow was distributed on the internet in the same way, then those advertising that were included in those broadcasts on TV and programs, radio programs, they should not be labeled or reported or etc. But if you do the stream and you then add some advertising video, for example, at the beginning of the stream or at the end of the stream, and these videos were never on this broadcast on TV, then these videos are considered online advertising and they should be registered and labeled and reported. Then there is additional exemption made for newsletters and mailings. So they should be marked as advertising and there should be information on advertiser, but you are not obliged to receive the ID and to report on this advertising if it's email, newsletter, or messenger mailings to your customers about your products. Which basically means that if you are doing this newsletter with help of some third parties or in benefit of some partner, then probably all the identifiers and all the reporting should be done. But if it's just your communication with your clients about your products, even if it's advertising, then you can just market advertising information on advertiser, but you should not get this ID. We are still closely monitoring the development of regulators' approach to this kind of exemption because it's not really clear. There are so many questions about this. And so far, we understand that if there is any contract involved in this kind of dissemination of mailings, and so there is some money flow between you and some partner, then this should be registered and it should be reported. This is the current understanding that we have about mailings. So this is kind of quasi exemption, not really full one. And there are also outstanding issues, everything that is currently discussed. So for example, this exemption about IP owning, like advertisers that are holders of IP rights to the advertised object. It's not clear how to apply these exemptions by licensees and franchisees who are not holders of IP right. They are just given the right to use some object. So whether this exemption also applies to them, but this like small details probably. In any case, everyone should report. So it's not a major issue probably. What is more interesting is advertising on one's own website or social network pages. How to deal with this? Because if I place advertising on my website and I agree that this is advertising, I do not have any dispute that this is information or advertising. what should I do with this? Okay, I can mark it as advertising. I can put my name as advertiser on this banner, for example, but I don't have any contract. And all this registration, obtaining of ID, and further reporting is linked to some contract, and I don't have one. So at some point of time, the regulator said that, oh, please create zero value contracts, which lawyers said never, never will not do that, because then the federal tax service will come and ask us about zero value contracts with ourselves.
With yourself,
so we are not doing this. So right now, the regulator and advertising data operators, they are developing some functionality that would allow to report about your own advertising on your own resources where you didn't have any contracts, but just clicking the tick box that this is a self promo. So this is under construction, and we hope by the end of the year we will have some more clarity about that. That is what officially promised by Roskomnadzor, for example, and the advertising data operators. So there will be some evolution of this. So far, what you can do and what we recommend our clients to do is to actually put all the marks, all the labeling, like advertising and name of the advertiser, and then you just wait. I mean, if you manage to register and obtain identifier, then it's great. But most likely, any operator of advertising data will say you that it's not possible at the moment if you don't have a contract. Please don't do the zero value contracts. We highly not recommend this. Also, unconventional formats and means of placement, that what Alisa just mentioned, all those unusual advertisings that were not thought of at the moment of drafting this law are now, regulator is understanding there are some dynamic banners, or there are some circles in Telegram, and it should all be somehow labeled. So this is all under discussion, under construction. So we need to be patient, but at the same time very active in raising those questions, because if you just sit quietly and decide not to talk about some format because you don't want to bring anyone's attention to that, it will be even worse at the end, because you will not have any certainty how to actually deal with this format. And also, the hot question is, of course, labeling of ads in restricted social networks. Alisa, for example, mentioned on the previous one of the previous slides the Instagram stories. But if you probably heard, in Russia, the Meta networks, they are restricted and they are considered like extremist organizations by the court. So they are blocked on the territory of Russia, which means that basically it's hard to imagine that someone would report to the register about any placement of advertising in these networks. But this question still arises because somehow you still can access those networks and they're still there. So it's a question that I'm not sure we'll find an answer to, and probably the most common recommendation is not to place advertising there because it's extremist organization. But yeah, probably moving from advertising to information is also an option. But yeah, this is a very sensitive question right now, for sure. And the event I was telling you about that we held recently, like last week, was the meeting with operators of advertising data, ORD in Russian. And after that, we prepared some recommendations from the advertising data operators. They are in Russian. Here will be the link. But in case you have Russian-speaking colleague, that it could be useful. These are the questions to the most complicated. The answer is to the most complicated questions. We didn't go to the basics. We did some advanced level of labeling of online advertising. which you are obviously now after you listen to our webinar. So some useful recommendations about self-promo, about reporting, about some unconventional ways of distribution of advertising. They're all there. So we are moving towards the end of our presentation. We have only two parts left. They are quite short, but they are still important. What to prescribe in contracts. So together with our colleagues who are active in the advertising law field, we drafted the addendum template, especially for this labeling of online advertising. It can be found online. Here is the link for that. Of course, it's not 100% applicable to any company, to any situation, but still it's like a universal checklist, I would say, that you can use in case you would like to change your contracts or draft your contracts from scratch in terms of this advertising labeling. What we prescribed there and what we would recommend not to forget to include in your contracts if you want to change them for labeling of advertising. So first, it's obligation of the agency, for example, or advertising distributor or other party, if you are an advertiser, to receive ID from advertising data operator and integrate it into the ad. Place the advertising mark and information on the advertiser on the ad. If you don't want to do it yourself, you can delegate this as well. Provide reports to the advertising data operator. Provide information on labeling reporting to the upon your request. For example, if you want to check what was done, then you can request this information and receive it from the agency, for example. And also make changes to the ad in case something changes in your website address or your company's name, etc. So you provide them with changes and they include those changes into the advertising. So these are main obligations. Then allocation of responsibility. Who is responsible for what? Of course, we are talking here about contractual responsibility. So if, for example, your agency is obliged to receive ID and report, then most likely they should bear the responsibility for not doing this, right? Non-reporting. It doesn't mean that the state authority will not place some responsibility on you as advertiser, for example, but at least you can reimburse your losses based on this contractual provision of allocation of responsibility. So this is quite important. Also, cost of services, of course, if you delegate something, most likely you will need to pay for that. So it's important to also think about this in the contract. And exemption from the confidentiality clause. Of course, everything that must be reported to the advertising data operator should not constitute confidential information. Most likely it will not, because under the law there is an obligation to provide this information, but still there are 7 operators, and it's better for avoidance of any dispute to exempt this from the confidentiality clause. So this is about contracts and about liability, also a very important thing to remember about. So what the law says currently, that the advertising data operators, advertisers, advertising distributors, advertising system operators, basically all data, not data, advertising subjects, they bear a liability of completeness, accuracy, relevance, and timeliness of information submitted to the register. But this is a general statement. It does not provide for any specific liability for those subjects. We have another provision in the law on advertising, which is more concrete, more certain, is that advertising distributors, they bear liability for failure to place their advertising mark and information on advertiser or the website on the ad. And this is already more certain. So we don't have a special liability for non-compliance with receiving IDs and reporting to the registry. So this first part on the left, we don't have special liability. And the regulator has promised a transition period till March 2023 that there will be no special liability, and we have not seen even a draft of this liability. It should be included in the Code of Administrative Penalties. It's not there yet. So we do not really expect any problems in terms of these identifiers or reporting until March 2023. We'll see how it will develop, but the regulator, they realize that their system is not perfect yet. It's not working properly. There are lots of questions. It's a completely new system in Russia, so it's still a transition period. But we have a general clause in the Administrative Offences Code about the responsibility for violation of the law on advertising. And there are some fines. It's approximate equivalent of euros 1,600 to 8,000 for legal entities. And this is quite a broad provision. And the Federal Anti-Monopoly Service said that they are already entitled to apply this liability to advertising distributors in case there is no advertising mark and information on the advertiser on the ad. So this second part on the left, actually there is already liability for that. There have not been any cases so far because the Federal Anti-Monopoly Service also understands this is a quite new piece of legislation. But they said, and we held a conference on advertising law, and there was a Federal Anti-Monopoly Service, and they said that if something is brought to them with this particular violation, they don't have any grounds not to apply this liability. So they will have to apply this liability. So we'll see how it will develop. So to sum up everything that we told you today, how to comply with the new law, it's kind of a checklist or step plan. So first, you need to carry out the audit of your own company's online activities and determine what is advertising, what is not, using those criteria that we mentioned in our presentation. We also recommend amending contracts with your advertising partners. For example, if you are a foreign advertiser, you most likely would like to delegate everything related to labeling of online advertising in Russia to some local agency or your local advertiser or local advertising distributor. So any local entity that would deal with some operators and other stuff. Then, if you prefer to do yourself, then you need to pick the advertising data operator, one or several, and engage with them contractually. So get the online account at their system, understand how they work, what exactly you can, what you cannot report through them, etc. Also, you need to align your internal procedures. It's very important to adopt relevant rules and policies, setting up the process of data collection and transmission, especially because in many cases, it's not done with lawyers. It's done by marketing people themselves because there is a huge pipeline of all the materials, the flow of advertising, and lawyers are just not involved in every step of that. So most likely at first you will be involved as a lawyer, and then most likely your colleagues from marketing will do it themselves. Then it's important to have all the rules and policies in place. Also, you need to control that released ads have the advertising market information on the advertiser and ID if you did not delegate it, or even if you delegated it, you would like to control it. So it's very easy to check. You can check it at any time. And we also recommend monitoring that posted ads and information about them corresponded to the information that is provided to the advertising data operators and to the registry. As I mentioned, we do not know the position of the Federal Tax Service yet, but we expect that they would somehow compare this information with all your tax reports, and maybe there could be some questions and issues in case they do not correlate. completely. So this is the step plan that we would recommend following. Of course, every situation is unique. Every situation should be analyzed in details. We are always ready to assist you with that, but generally this is the step plan that we have. So before we move to questions that I see already in the chat, and please feel free to add your questions to that, we would like to remind you that you can subscribe to our newsletters in English using these links and QR code to receive some new alerts on new legislation and invitations to some webinars or events that we hold. Also, we have a seamless YouTube channel where you can find some recordings of other webinars, either in Russian or in English. Please subscribe and give us some likes and share with your colleagues and friends. And also, if you're a Russian-speaking colleague, we have some information about YouTube and Telegram activities, and in general, we have this public activity regarding the advertising law. We have a community on advertising law, and we share a lot of information there, some lectures, some events. So if you are a Russian-speaking colleague, please join us. So this is all from us. These are our contacts. So please feel free to contact us if you would like some assistance with advertising or not only advertising. And I think we are ready to move to the questions. Right? So the first question is, what if it is the seller's own website, but dedicated to a specific product, only which extensively describes all the characteristics of the product, its advantages, benefits, achievements, and reference to the addresses of the shops where such products may be purchased? Is it advertising? Thank you. It's a great question. Actually, these mono websites, as we call them, mono sites, where they are not about all activities of the company, but only dedicated to specific products. It wasn't discussed with the Federal Anti-Monopoly Service or Roskomnadzor yet. We would think that it really depends on the contents of the website. We would think that per se, it's still the official website of the producer of this good, for example, or the seller of this good. And it informs about its characteristics, about its components, ingredients, or whatever. So most likely per se, it can be not advertising, can be just information. But when you say that it extensively describes characteristics, advantages, benefits, and achievements, I can imagine in my head that it can be advertising. It can be very much appealing to the consumer, attracting its attention, and then we go back to this criteria that we mentioned, and it can be advertising, or some part can be advertising. So we really need to look into this content of this website. Okay, I see that there are also questions about website, right? So advertising website published before 1st September. We do not have to comply with the labeling and reporting. Do we need to comply if there is an update on the website after the date and new articles pages are published? Yeah, that's why I said that these exemptions about 1st September are quite rare, probably, because if your website is still there, I mean, it's still online and you somehow probably attract the attention of the customers to your website, then the distribution of this online advertising was not fulfilled by September 1st. It's still there. So I would say that in this case, you still have your online advertising that you need to label and you need to report on. I know, Alisa, what do you think?
Yes, absolutely. I mean, most of the websites have been available before. All of the apps that are currently used for online ads, of course, have been existed for a long time. So I do not really believe that that's the defining element. The defining element is whether you post any new ads or whether the ads that you have posted before have been posted for a specific period, which is after the 1st of September as well. So we hopefully do have some positive position now that not everything needs to be labeled, which existed before, but still I think the authorities will look very closely how it was really prescribed in the contract, what was the period of publication, whether it just remained there as an archive article, for example, or whether it was supposed to be there for a year or so. So it will be on a case by case basis, of course, but
Yeah. Does it also specifically mean that we don't need to add label advertising to such website if it was published before? Yeah, I think that we answered that. We really think that if it's still advertising, then the new legislation applies to that. Then, do you recommend marking advertising of your own products, which is considered as such according to the explanation of the FAS on the advertiser's own official website in their own social media accounts, and how to report on it? After all, the advertiser does not draw up any acts with himself. In this case, only the advertiser reports on advertising. Do you already have such examples in your practice? Yeah, thank you for this question. It's very good one. I think I answered the major part of it during the presentation. Yes, if it is advertising on your website, you need to mark it, you need to label it with this label advertising and information on the advertiser. And yes, we do see such examples in our practice. This is okay because the liability is already there, so everyone is really worried about those labels. And reporting, we need to wait. We need to wait because still there is no functionality available for that. So let's wait until the end of the year. There is no liability for absence of reporting. Once the functionality is there, just make sure that you use it, and probably for the past periods as well. In your opinion, is it necessary to mark, and if so, how, informational posts that appear in the feed of a specific audience using targeting, special settings in the social network's advertising account? That is targeting in itself an indicator that an informational post in the advertiser's own account, for example, about the event in the company or similar, is advertising and is subject to labeling? So I think there are two parts, right? So first, informational posts that appear due to the targeting. So here we need to understand whether it's informational posts or whether it's actually advertising posts. So, but if you use any advertising instruments to promote this post so that it is shown to some people outside your group, for example, who might be interested in this event, then I would say that it is advertising as, and yes, it should be marked. And if you're using this targeting tools of VK, for example, then you are involved in their advertising cabinet, and they will most likely report themselves about your payments and about your statistics on your advertising. So I would say yes, but I would really love to see those informational posts and see the mechanics, how exactly.
yeah, I mean, it depends. I think it could be just news which are distributed geographically to a specific audience. So it really depends on the context and you know, the content, as we always say, of this post.
Yeah, exactly. Yeah, I'm just worried about this targeting using. So it's like normally targeting means that you show this information to some new audience. Yeah. So if it appears, for example, on my feed and I never was subscribed to your account, then it's likely to be advertising. But yeah, we really need to understand what's behind that. And if targeting itself as an indicator, the informational posts in the advertiser's own account, is advertising. So yeah, so here's what Alisa said, right? So if it's just a news about the event or some information about your company in your own social network account, then per se it's not advertising, so it should not be marked and labeled. But if you again use some additional advertising instruments, then we need to see what kind of instruments, what kind of mechanics are behind this distribution. Okay, the law says IP holders might delegate their responsibilities of reporting to advertising distributors. However, the companies operate through ad agencies and they not always can negotiate such delegation to the ad distributors. Is it right to delegate said responsibilities to the ad agency and authorize it to necessary reports on behalf of the company? Oh yeah, thank you for this question. Yeah, it's a pain of many companies and many agencies as well, because they are not even named in the new legislation. There is no such subject of regulation as a advertising agency, although of course the main work under these new rules is done by advertising agencies. So yes, you can delegate this to advertising agency, and we really think it's a best probably option right now. But yeah, the law says that you need to delegate it to advertising distributors. So what you can do, for example, you can say that your agency is obliged to delegate it to advertising distributor, and this somehow can be in compliance with this law. But if it's not possible, I don't really think it will be much of an issue. This is my opinion. I really think that if you delegate and if you have contractual responsibility for failing or for reporting, etc., and then your risks are mostly covered. And this weird exemption with IP holders, I don't really think that many advertisers will successfully use this exemption. We'll see how it goes. But the only thing that it helps with is exemption from the liability, like a public liability. Maybe this liability will mostly on distributors. We'll see. We don't have this liability yet, so we don't know what we're exempted from even. So but yeah, answering your question, it's right to delegate the responsibility to the ad agency. We really think it's a standard way of doing it right now. Yeah, Alisa, do you have anything to add?
Yes, no.
Okay, great. Question to Irina. This is me. What are your prospects in the future of the professional websites for medical professionals which are kind of falling out of the law zone? What should they do with their materials on medicine? This is a good question as well. And this is still a gray zone, actually. So if we're talking about some professional websites where no one without medical education proved with documents can access, then probably we can talk about some limited circle of people. And then our second criteria of advertising is not met. So it's not advertising if it's a limited circle of people. But of course, all of us understand that it's not always very strict in terms of access, that people can actually access those websites, and it's not very difficult. And in this case, the Federal Anti-Monopoly Service says that if it's not difficult to come into the circle, then it's not really the limited circle of people, then it's unlimited circle of people, then it is advertising. And at the same time, advertising of RX products, so the recipe-based products, it is very much restricted and it is prohibited for the general public. So there are two prospects, I think. First, that probably the pharmaceutical industry will initiate some changes in the law, allowing some advertising of RX, the recipe-based products on the internet, because now it's not directly allowed. Not for general public, but at least for medical professionals. And then we will see how this will be reported, because right now it's even hard to report this, because basically this advertising of FX products is prohibited on the internet. So I think right now websites are trying to think that they are a limited circle of people and it's not advertising then. But yeah, we'll see how it will be developing. Okay. Very interesting and fulfilled with insights. Thank you, Irina. Lisa, thank you very much. It's very nice of you. Will the presentation be shared? Of course. What would be your general recommendation for liability clause for not fulfilling the obligation by the agency, taking into account the campaign's budget, who are contractually obliged to transfer data to the operator and the registry? So yeah, you can refer to this template that we gave a link to, and there I think we have two options, if I'm not mistaken. So first is a lump sum, like this will be your fine for not complying, and the second is like a percentage. So and if there is a huge budget, then it can be a percent of this budget of the campaign, etc. And of course, the obligation to pay for any losses that advertiser may have in this case. So yeah, these are two main things, I think. Yeah, Lisa, what do you think?
Yes, I think just add the indemnity clause, definitely. So if you get fined, then the agency would have to compensate that, and for losses as well.
Yeah. Okay, there's another question. A lawyer aspiring to act as an arbitrator and promoting himself herself as an arbitrator who plays in social media and information about taking over the powers of an arbitrator for a case while placing in social media such information, is he or she essentially advertising himself as an arbitrator or not? Alisa, what do you think?
Self-promo. Well, I think this is a very particular case. I don't think anybody would consider that this is advertising. Of course, we as professionals, we advertise ourselves all the time as lawyers. So, I mean, just post information about your legal practice like that. I don't think then FAS and Roskomnadzor will be as strict.
Yeah, exactly. I mean, it's like information about the company's activities. So you are the company. Imagine that you are the company and you are active and you act for this lawyer, for this client, or for this case. And yeah, you just tell your audience about that. And I don't think it's advertising. But yeah, if there's some, banner on someone else's website, for example, with your picture saying the best arbitrator in the world. So yeah, this probably will be advertising. But yeah, if you do it on your own websites or social networks, that's the manufacturer of the product sells the product to the distributor at a discount. The distributor, on its own behalf, concludes an arrangement for advertising and purchased goods on the marketplace. Who should be considered an advertiser in such a situation, and who should register the advertisement? I think so. The advertiser under the law is the one who basically designed the advertising and who determined the goals and the way this advertisement is distributed. So in this case, it seems that the distributor, who is actually now the owner of goods and who is entering into contract with marketplace, will be the advertiser, like the final advertiser in this chain. Because as we understand your case, between manufacturer and distributor, there is no contract for advertising whatsoever. So then and then it depends on the contractual scheme that this distributor and marketplace would have, like whether this advertiser or distributor will register the advertisement, or it will be done by the marketplace. For example, if you are working with Ozon, Ozon has its own the system as an operator of advertising data, then most likely they will do the whole job. Yandex Market as well. Yandex is an operator, so they will do the whole job. You will not need to do anything. But yeah, if it's another marketplace, then you need to agree about this in the contract, probably. How limited it should be? I think it's a question about the limitation of the circle. There is no number. Yeah, it's not number. You know, it's a mechanics of adding people into this circle, basically. So, for example, we have a Telegram chat named Advertising Law, Reklamne Pravo. So the one that we gave the link to. And now we have almost 2,000 people there. It's closed Telegram chat, right? So you can't just find it. You need to have a link to apply for entering this chat. But it's very easy to enter this chat because basically administrators will just ask you what's your name, where do you work, and then they let you in. So in this case, we cannot say that this is a limited circle of people, whether it's 100 people or 2,000 people or 10,000 people. It's unlimited circle of people because we do not know who will be there next day. And there is no like particular factor or criteria for allowing or not allowing people in. But this is different with some specialized websites, for example. It can be different. I'm not saying that it's always different, but if it's very, very limited scope of people that you allow only, for example, pediatricians with this particular degree, and you check their documents, and only after that they are allowed to this limited circle of people, then probably this will be a really closed community, and you can prove in case of a dispute that this was a limited circle of people, that it was not easy to be included into this, and that's why it's not considered as advertising. Hopefully we answered your question. Okay, I don't see any questions right now left, so I think we can wrap up. Thanks a lot for being with us today. Thank you for your great questions. They're just to the point, so it helped us to give even more information to you. Thanks a lot for that. If you have any questions left, please contact us. We'll be glad to assist you in your business in this advertising law reality that we are facing right now. Keep being with us, subscribe to our alerts, and see you on the next events. Thank you very much.
Thank you. Thank you, everybody.
Have a nice weekend. Bye-bye.
Bye-bye.